Hello, Bacho. Let's see the first question for today. So we will be solving this passage today, and then we will be moving on with the questions. Okay, let's read the passage. The Law Commission's recommendation that the offence of sedition be retained in penal law, albeit with some safeguards, flies in the face of current judicial and political thinking that the country may not need this colonial wastage anymore. Section 124A of the IPC, which describes sedition, seeks to punish speech or writing that brings or tries to bring into hatred or contempt, or excites or tries to excite disaffection towards the government established by law. Its validity was upheld by the Supreme Court as far back as 1962, but with the reservation that it would be a constitutionally permissible restriction on free speech only if the offence was restricted to words that had a tendency to incite violence or cause public disorder. However, legal experts have pointed out that the panel's report fails to consider how far free speech jurisprudence has traveled since then. While keeping pending sedition cases in abeyance last year, the court had observed that the rigors of Section 124A of IPC are not in tune with current social milieu. The Union government, too, had decided to re examine and reconsider the provision. The time has come to consider the provision in light of recent principles to test the validity of any restriction of fundamental rights, especially free speech. Given its overboard nature, the sedition definition may not survive such scrutiny. The Commission has sought to address two concerns usually raised about sedition: its rampant misuse and its relevance to the present day. It has repeated the hackneyed argument that a law's misuse is no ground to withdraw it. However, it has failed to consider is that its very existence on the statute affords great scope for its unjustified use, often with deliberate intent to suppress dissent and imprison critics. It is doubtful if a mere prior sanction requirement, as mooted in the requirement, or a mandatory preliminary probe will lead to fewer sedition cases. Further, the panel has argued that the fact that something is a colonial era provision is no ground to discard it. It has justified the need to keep sedition on penal statute by citing the various extremist and separatist movements and tendencies in the country, as well as the ever proliferating role of social media in propagating radicalization. This may not be a sufficient reason to retain it, as divisive propaganda, incitement of violence, and imputations affecting social harmony can be curbed by other penal provisions. In fact, an effective legal framework against hate speech is what is needed more than one to penalize speech or writing that targets the government. Notwithstanding the report, the government should consider the repeal of the provision. Okay, so basically the author is totally against the law commission's report of like keeping the Section 124A in the penal code. So the law commission has given its own reasons for keeping it and saying that as because just it is of a colonial era, that's not a reason why we should withdraw it. Or they have also said that due to the there are many separatist groups in the country, there has been many radicalization due to the social media platforms. So the sedition law should be kept in the country. And but the author is totally against this, and he is like whatever the law commission is saying, he is negating their facts by uh, giving some other statements of his own. And he feels that sedition, he is totally in favor of law of sedition being disqualified from the penal code. And that is what he has said, and in the ending he says that the Supreme Court should once again reconsider it for repealing of this provision. So basically the author is totally against the what the law commission has said. Okay, so let's see the question. Based on the information provided in the passage, which of the following can be directly inferred? The Supreme Court's decision in 1962 to uphold the validity of Section 124A of the IPC was based on the consideration of current free speech jurisprudence. The Supreme Court's decision in 1962 to hold IPC based on the... No, this is not correct. This is like not a option which we can choose, because we have to find something which can be directly inferred, and this really can't be inferred from any line. The Law Commission's recommendation to retain the offence of sedition with some safeguards aligned with the judicial and political thinking in the country. This also can't be inferred. This is also not mentioned that Law Commission ने जो report ले आया है वो अभी present जो जैसे political thinking है उसके साथ related है, ऐसा कुछ नहीं mention किया हुआ है. The existence of sedition law on the statute, law on the statute provides ample opportunities for its misuse, leading to the suppression of dissent and imprison of critics. I think this was mentioned in the passage. जब मतलब we will see that, let me find out the line. Reservation. Actually, there was a line where the author said that the existence of this law will only result in its misuse. No matter whatever, like whatever other things you include in it to prevent the misuse of this law, but if this law is existing, then only it will result in its misuse. हाँ ये देखो, it has repeated the hackneyed argument that a law's misuse is no ground to withdraw it. Okay, तो लॉ कमीशन क्या बता रहा था कि सिर्फ एक लॉ मिसयूज हो रहा है इसका मतलब ये नहीं कि हम वो लॉ ही हटा दें। तो फिर ऑथर ने क्या कहा है कि ये लॉ एग्जिस्ट करता है मतलब ये मिसयूज हो गए, द वेरी एग्जिस्टेंस ऑफ दिस स्टैट्यूट एफर्ट्स ग्रेट स्कोप फॉर दिस अनजस्टिफाइड यूज, कि ये एग्जिस्ट करता है तो मैं ये मिसयूज होगा ही, तो ऐसे बताया है ऑथर ने। So option C will be the right answer. और ऑप्शन टी क्या कहता है, द गवर्नमेंट्स रिकंसिडरेशन ऑफ सेडिशन प्रोविजन इज प्राइमरली ड्रिवन बाय कंसर्न्स रिलेटेड टू एक्सट्रीमिस्ट एंड सेपरेटिस्ट मूवमेंट्स एंड द रोल ऑफ social media. No, government's reconsideration is not driven by these things. This was told by the panel commission that sedition, it is important to keep sedition law because there are separatist groups and there is radicalization due to the presence of social media. So sedition law is it is important to keep sedition law. बट गवर्नमेंट का जो रिकंसिडरेशन था सेडिशन प्रोविजन के ऊपर वो इसलिए नहीं था. दिस वाज नॉट द रीजन फॉर द रिकंसिडरेशन. सो ऑप्शन सी विल बी द करेक्ट आंसर. व्हिच टाइटल बेस समराइजेस द मेन फोकस ऑफ द पैसेज? चलिए देखते हैं. The historical significance of section 124A of the IPC. Does the passage only talks about the historical significance? Not at all. Historical significance के बारे में तो बस ये बताया गया था कि सुप्रीम कोर्ट ने इसको जब पहले बार ये शुरू हुआ था, that was in 1962. तो historical significance ये तो पूरा गलत हो गया. The need for safeguards in retaining the offence of sedition. Okay. The role of sedition in modern society, a comparative analysis. नहीं, it's not about मॉडर्न सोसाइटी में सेडिशन का क्या रोल है, इसके बारे में तो नहीं है. रिपीलिंग सेक्शन 124A ऑफ द आईपीसी a legal and political dilemma? No, it doesn't really show a dilemma. इसमें डिलेमा तो कुछ है नहीं. ये जो बात है कि लॉ कमीशन ने अपना रिपोर्ट दे चुका है और ये ऑथर जो है ही इज स्ट्रांगली अगेंस्ट दैट रिपोर्ट एंड ही इज इन फेवर ऑफ रिपीलिंग दिस एक्ट. सो नो डिलेमा हैज बीन shown here. So the correct answer becomes option B, which says that the need for safeguards in retaining the offense of sedition. So option B will be the correct answer. This is the best suitable answer for this question because we have already negated all the other three options. So option B becomes the best suitable one. Which of the following conclusions can be drawn from the passage? The Law Commission's recommendation to retain the offence of sedition in penal law is in line with the current social milieu and free speech jurisprudence. No, this was not the line. ये तो अलग था. ये तो था कि जो गवर्नमेंट का रिकंसिडरेशन था, that was in line. Just a moment, let me find out the line. While keeping pending sedition cases in abeyance last year, the court had observed that the rigors of Section 124A of IPC are not in tune with the current social milieu. हाँ, तो कोर्ट ने ये ऑब्जर्व किया था कि the rigors of Section 124 ए जो है, दिस डजेंट फिट टू द करंट सोशल ऑर्गेनाइजेशन, करंट सोसाइटी का जो सिचुएशन है उस पे ये फिट नहीं करता है जो सेक्शन 124 ए का प्रोविजंस है, एंड दैट वाज द रीजन व्हाई दिस particular section was sent for reconsideration. Okay, I will highlight this line. Option B देखते हैं. The rampant misuse of sedition law justifies its withdrawal from the penal statute. नहीं. Option C, existence of sedition law provides opportunities for the, I think option C will be the correct answer. Rampant misuse of sedition law, नहीं ये तो है ही नहीं, बिकॉज इसमें तो बताया गया था कि लॉ कमीशन ने साफ साफ बताया था कि कोई लॉ मिसयूज हो रहा है, इसका मतलब ये नहीं कि हम उसको हटा दे. मिसयूज इज नॉट अ ग्राउंड दैट यू कैन रिमूव अ लॉ, सो ये तो हो ही नहीं सकता. द एग्जिस्टेंस ऑफ सेडिशन लॉ प्रोवाइड्स अपॉर्चुनिटीज फॉर इट्स अनजस्टिफाइड यूज एंड सप्रेशन ऑफ डिसेंट. दिस इज व्हाट द ऑथर हैज सेड. This was one of the viewpoints of the author which he said in a line. So this will be the conclusion. Option C will be the correct answer. The repeal of section 124 of IPC is necessary to curb extremist and separatist movement. We can't conclude this. This is not mentioned. कि repeal necessary है ये टू कार्ब एक्सट्रीमिस्ट एंड सेपरेट, जबकि ये बताया गया था, लॉ कमीशन ने ये बताया था कि बहुत सारे सेपरेटिस्ट ग्रुप्स है, सोशल मीडिया के द्वारा रेडिकलाइजेशन हो रहा है, तो सेक्शन 124 रखना जरूरत है, और यहाँ पूरा उल्टा बता रहा है, तो ऑप्शन सी बिकम्स द करेक्ट आंसर. फोर्थ देखते हैं, विच ऑफ द फॉलोइंग वर्ड्स फ्रॉम द पैसेज रेफर्स टू द deliberate intent to suppress dissent and imprison critics. देखते हैं. प्रोलिफरेटिंग हैकनेड अनजस्टिफाइड इम्प्यूटेशंस. प्रोलिफरेटिंग मतलब क्या होता है? इंक्रीज करना, बहुत ज्यादा कुछ बढ़ रहा हो तो वो होता है. हमें ढूंढना है ऐसा वर्ड जो, अच्छा, जो डिसेंट सप्रेस करता है, मतलब बेसिकली जो क्रिटिसाइजेशन को सप्रेस करता है. हैकनेट, हैकनेट का मतलब क्या होता है? हैकनेट का मतलब होता है बहुत ज्यादा ओवर यूज करना और लाइक क्लीशे कर देना, ऐसा. सो हैकनेट भी नहीं होगा. अनजस्टिफाइड मतलब तो जिसका कोई वैलिड रीजन ना हो, ऐसा ही. इम्प्यूटेशन ही होगा फिर, क्योंकि इम्प्यूटेशन का मतलब होता है कि कोई भी चीज को कुछ एट्रीब्यूट करना, कोई भी चीज को कुछ एट्रीब्यूट करना. सो और वो भी इन अ नेगेटिव सेंस, सो इम्प्यूटेशन विल बी द करेक्ट आंसर, क्योंकि इम्प्यूटेशन का मतलब यही होता है कि नेगेटिव सेंस में कोई चीज को कुछ एट्रीब्यूट करना. सो या, इम्प्यूटेशन इज द करेक्ट आंसर. Based on the passage, what can be inferred about the Supreme Court view on the rigors of Section 124A of the IPC? The Supreme Court believes that the rigors of Section 124 are necessary to maintain social harmony. ऐसा तो बिल्कुल नहीं है. सुप्रीम कोर्ट का तो ये मानना था कि ये जो इसका जो है, मतलब सेक्शन के अंदर जो प्रोविजन है, ये प्रेजेंट सोशल ऑर्गेनाइजेशन में फिट नहीं करता है. Supreme Court considers the rigors of Section 124 as inconsistent. This is the correct answer. Just right now only we have read about this line. Rigors of Section 124A are not in tune with current social milieu and court had observed. So this is the correct answer. दूसरी क्या बताता है? The Supreme Court has upheld the rigors of Section 124 without any reservation. नहीं, ऐसा तो बिल्कुल नहीं है. The Supreme Court believes that the rigors of Section 125 are, ये तो पूरा उल्टा हो गया. So option B becomes the correct answer. Okay, thank you. We have finished this passage. I hope everyone of you have understood.